Becoming more familiar with the latest changes to FERPA. The Family Education Rights and Privacy Act, known as FERPA, generally prevents schools from sharing student data without parental consent. Schools have a great deal of flexibility under FERPA to disclose students' data and education records in certain settings. In the context of school safety, FERPA makes an exception to its restriction on data sharing should knowledge of such information be necessary to protect the health or safety of students or other persons in connection with an emergency. FERPA is administered by the Family Policy Compliance Officer in the Department of Education. 8 ways to ensure school is FERPA compliant. Raise FERPA awareness. Ensure that all employees are aware of FERPA. Confirm that FERPA applies to you. It applies to any school that receives federal funding. Know the rights, protections, and exceptions. Every school employee must learn, understand, and comply with FERPA. Choose compliant vendors. Third-party vendors have to comply with FERPA. All in-school employees should be trained annually. Implement and complement policies and procedures. Encrypt files and emails, and implement other prevention tools. In the area of immigration and custom enforcement in the school, under federal law, state and local education agencies are required to provide all children with equal access to public education at the elementary and secondary levels. Listed on the next few slides are some frequently asked questions regarding the school in U.S. immigration. The first question: if the school resource officer is a police officer, are they required to report undocumented students? They are not required to report any undocumented students. Schools are considered a sensitive location in which ICE officers and agents are to refrain from enforcement actions unless there's an extraordinary circumstance involving public safety. What is the role of the SRO in removing undocumented students? Generally, the officers have no role in the removal of undocumented students. Third question: what are the FERPA protections and are they triggered, and if so, when? Under the Family Education Rights and Privacy Act, school districts must maintain the confidentiality of all personally identifiable information and educational records related to students. FERPA permits school districts to disclose student information when it's in compliance with a judicial order or lawfully issued subpoena. What are schools' obligations if ICE comes to the office and wants to access students' records? Access to student records should only be allowed if the requesting agency has a valid court order or subpoena in compliance with FERPA or immigration laws or regulations. And what information are schools allowed to collect from parents' families for enrollment? In Plyer v. Doe, the U.S. Supreme Court held that a state may not deny access to public education to any child residing in the state, regardless of whether the child is present in the country legally. FERPA compliance in the digital age. As of September 2019, at least 10 school districts have been in the news for their ransomware attacks, and the U.S. Department of Education reports that hundreds of educational data breaches occur annually. The United States Department of Education established the Privacy Technical Assistance Center as a one-step resource for education stakeholders to learn about data privacy, confidentiality, and security practices related to student-level longitudinal data systems and other uses of student data. The State Student Privacy Report Card, released earlier this year by the Parent Coalition for Student Privacy and the Network for Public Education, gave no state the top grade of an A+. The top scoring state, Colorado, earned a B. Schools and an educational agency are responsible for the data of their students, and no one should have access to that besides parents, students, and third-party service providers. The laws and regulations also apply to those providers to protect that data as if they were the school. In the area of surveillance cameras, according to the National Center for Educational Statistics, more than 80% of public schools and more than 94% of high schools in the United States use security cameras to monitor students during the 2015-2016 school year, nearly doubling the number of schools using camera a decade earlier. Some guiding principles with the use of surveillance cameras. The Fourth Amendment prohibits governmental entities such as public schools from conducting unreasonable searches. When the video surveillance recordings are made in locations where individuals have a low expectation of privacy, such as when they are in the public places and their movements and actions are in plain view, courts have rejected claims that such recordings are unconstitutional searches. Recordings made in locations where individuals have a higher expectation of privacy, such as bathrooms and locker rooms, they're more likely to be an unconstitutional invasion of privacy. School districts should notify the school community through policy, statements, and handbooks and signage that cameras are located throughout school property, and individuals should anticipate having their images captured. The Electronic Communications Privacy Act and state wiretapping laws. The use of audio surveillance recording raises other legal issues and potentially creates criminal liability for unwary administrators. The Federal Electronic Communications Privacy Act of 1986 prohibits the intentional interception of any oral communication, except where one party to the conversation has consented to the recording. The Family Education Rights and Privacy Act provides parents and eligible students the right to access education records. Images of students captured on surveillance records qualify as education records when photo or video is directly related to a student and maintained by the educational institution. All states have adopted laws providing individuals access to public records. Many states have defined public records broadly to encompass video images. Some ways that schools might unintentionally violate FERPA. Under FERPA, schools are responsible for what their vendors do with data. That means that if a vendor intentionally or accidentally misuses students' education records, the school will still be at fault. Parents own the FERPA rights of their child until the child turns 18 or enters a post-secondary institution. If a school denies access to a student record to a parent of a student under the age of 18, that is a FERPA violation. FERPA is not a confidentiality law. It only protects what's in a student's education record. Under the law, a school may disclose directory information, which is a blanket term for basic identifying data such as a student's name and address, to a third party if it has taken certain steps, including giving parents and eligible students the right to opt out. FERPA allows educators to share information about a student internally within the institution or school district, but basically any employee or agent who has a job that gives them a need to have access to certain information about the student. If there is a FERPA violation, if parents or eligible students believe that their rights under FERPA have been violated, they have to file a formal complaint with the department. The Secretary of Education must take appropriate actions to enforce FERPA and to investigate violations. With privacy in education, federal law, the Family Education Rights and Privacy Act, protects student records to some extent. FERPA, commonly known as the Buckley Amendment, is one of the oldest privacy laws on the book. Privacy abuses can range from grades bandied about in hallways to the non-consensual exposure of student information and photos on the internet. FERPA applies to schools that receive federal funds through a program of the U.S. Department of Education. Some tips for parents and adult students. They should read everything that is sent home with your child from school or sent in the mail. Always question why information about the student is being requested. Find out how your school defines directory information. Ask for a copy of the school or district policy on surveys. Teach your child to tell you about surveys and questionnaires. Ask for a copy of the school or district policy regarding requests to access the educational record. Ask for a copy of student school or district policy regarding the videotaping and photography of students. Keep in mind that your child may participate in programs that are not formally sponsored by the school and may be associated with the school nonetheless. Request the opt-out form if you do not want the child contacted by military recruiters. Review your child's education record periodically and ask to see the access log for the education records of your child at least twice a year. If your child experiences a breach of confidentiality of student records or another kind of privacy abuse, document it carefully in writing in addition to talking to teachers, staff, and other administrators about the matter. Write a letter to the appropriate administrator and, if necessary, the school board. If a privacy invasive situation that your child has experienced is widespread or systematic, organize with other parents. And these are some of the federal laws that govern privacy of educational records. You have the Family Education Rights and Privacy Act, which is FERPA, Protection of Pupils' Rights Amendments, the No Child Left Behind Act, the USA Patriot Act, the Privacy Act of 1974, and it's the Campus Sex Crimes Prevention Act. What exactly are education records? Under FERPA, education records consist of anything directly related to a student that is maintained by an educational agency or institution. Education records include much more than test scores or class standing. They can include health information, description of physical appearance, family economic circumstances, criminal history, ethnic background, political and religious affiliations, and psychological test results. Do parents have a right to see their student's record? Yes, parents or adult-age students may review their records, including medical or psychiatric evaluations. The right of access provided under FERPA does not prevent a school from withholding transcripts or other official recognition of completed work until all tuition, fees, and other charges are paid to the school. When we talk about the internet, we talk about internet publication of information or images. The publication on the internet is considered a disclosure of information from the education record and must comply with FERPA. Information in aggregate can be posted if students are not identified. Once we gather all this data, at some point we have to get rid of the data, so here is the best practices for data destruction. FERPA does not provide any specific requirements for educational agencies and institutions regarding disposition or destruction of the data they collect or maintain themselves, other than requiring them to safeguard FERPA-protected data from unauthorized disclosure and not to destroy any education record if there is an outstanding request to inspect them. Part B of the IDEA defines the term destruction as a physical destruction or removal of personal identifiers from information so that the information is no longer personally identifiable. Modern electronic data storage devices are extremely resilient, and data recovery techniques and technology are highly advanced. Data are routinely recovered from media which have been burned, crushed, submerged in water, or impacted from great heights. Data destruction encompasses a wide variety of media, including electronic and paper records. The choice of destruction methodology should be based on the risk posed by the sensitivity of the data being destroyed and the potential impact of unauthorized disclosure. So there's 3 different categories of data destruction. The first one is clear, which is a method of sanitation that applies programmatic software-based techniques to sanitize data in all user-addressable storage locations for protection against simple, non-invasive data recovery techniques. Then we have purge, which is a method of sanitation that applies physical or logical techniques to render target data recovery infeasible. And the last category is destroy, which is a method of sanitation that renders target data recovery infeasible using state-of-the-art laboratory techniques and results in the subsequent inability to use the media for storage of data. And then here are the references to the present.